This presentation is going to be on finding family in last will and testaments. So what is a last will and testament? This is a legal document that a person writes or dictates before their death, bequeathing real and personal property to individuals. Originally, a will represented property and land, and a testament represented personal property, kind of like personal items. And then over the years, the two of these were combined. One of the main purposes of a will in the beginning was to distribute land, not necessarily wealth or money. Women did have wills also, but usually only if they were widowed or unmarried. The person making the will is called the testator. So if the will was written in the hand of the testator, it's called a holographic will. Typically, the wills that you see are written by a lawyer or a judge, and they're typically always copies that are written within the court books. If a person died without having a will, they died intestate. So in this case, the court will distribute their estate according to the laws of that time and the location. A will must be signed by the testator or at least have their mark. This is something that is very important. Although remember that many people in early days were illiterate, so they literally dictated their will and then they would put their mark, which would have been an X or some symbol for their name. It will then have the signature of witness or multiple, and the witness needs to be someone who is not mentioned in the will, an impartial party, and then they will attest to seeing the testator sign the will in their own hand and were of sound mind. And that is one very important piece. Almost every last will and testament, not all, but most, would say that the testator was of sound mind, meaning that they were the ones giving this information, they were not being told to do so. And a will was typically written when a person believed they would not live much longer. It could have been old age or illness. If they were sick, a lot of times they might get better. And if this happened, the person would often update or amend their will at a later date. So this is why it's known as the last will and testament, and it makes others that were previously written void. And you can usually tell if there had been more than one will, because in the beginning it will say that all others are null and void before that. If there was just a quick revision to the existing will, this is called a codicil, and it would be accepted as part of the will in case the person passed before a new one could be written. You might have this in the case that a father has written a will and included all of his children, but perhaps one of his children dies before he does. So he'll make a codicil for his grandchildren instead, or to include them. What is the importance of a will in genealogical research? A large importance of wills is that they often state the relationship between the testator and the individuals mentioned in the will. It can also indicate the age of the testator's children. Often instructions are left for their minor children. It may also mention if their daughters were married and if they were still living, which that is something that is very important in these older wills, since we often don't have records of when the females died. A will can also shed light on the status of the person by showing what property they had. Keep in mind that household items had much more value hundreds of years ago than they do today. There might be certain things listed in there that today we wouldn't think twice about, such as just kitchen items, a bed, a pot, and so forth. So furniture and kitchen items were often left to women, while the land and property were more often left to men. One exception to this, often if it was an older couple, there would be a stipulation that their wife would remain on their property for the rest of their natural life, and that perhaps a child is to take care of them, but that the wife is going to stay on that property. The worst wills to come across are ones that simply leave everything to their wife and they do not even name her. So the man could have had multiple wives during his life, so this leaves speculation as to which wife. I've seen one in the past where it just says, I leave everything to my beloved wife, his personal and real property, nothing else. And then a will that states to simply divide their estate amongst all their children can also be a little frustrating, because that doesn't tell you who their children are, how many they are, if they're all alive, if they're all old enough to inherit, or if they're children by the same spouse. In both of these cases, there's typically no names given, but hopefully if it was probated, you can at least find a relative who was the executor or administrator that you might be able to recognize the names. So last will and testaments typically had a format. Not all of them followed this, but this is the typical setup for a last will and testament. It would begin by stating the county and state, then the person's name, the condition of their mind and body, and sometimes religious beliefs and the date. The date on last will and testaments varies. It could be listed at the very top in the first sentence, or it might not be written until the very end of it. But you always want to read through to see what the date the will was written, because it's usually always going to be different than when the will was probated or recorded. The first item of a will usually has instructions to pay any debts that they may have had, funeral expenses, and perhaps how they wish to be buried or religious beliefs again. This bit is more common for those who had a good bit of items or wealth to leave behind, because therefore they knew they had debts and they would be able to be paid. And then if they left instructions for funeral expenses and others, you know that they had some wealth. They would then begin bequeathing property and items to others. So men usually began with their wife, sometimes by name. Her maiden name is rarely ever going to be mentioned in a last will and testament. Often property would be left to the wife during her widowhood. If she were to remarry, the will may state that the property reverts to someone else as to not go to the new husband. So even though you might not know if the wife is the first or third wife, the way that they are left items and phrase can help you give an indication of age. So therefore, if it is an elderly man and his wife were quite elderly, she would probably remain a widow if she has a place to stay and live and someone to take care of her. But if a man died and his wife was fairly young and had several young children, most likely she would remarry. And by remarrying during that time, her new husband would get anything property-wise, money that was hers. So that's why those stipulations are listed in those wills. And often it'll say if she were to remarry, the property or wealth is to be divided amongst their children when they come of age. So that can be a good indication of the wife's age. Next, they would usually begin to leave things to their children, beginning with their sons in order of age, but this is not always the case. Daughters would often be mentioned after the sons. If the daughters were married, they may be listed by their husband's name. And this is quite good for genealogists, because then you know, at least during that time, who she was married to. But it can also cause confusion if you don't know the daughter's given name. And so, again, you might think that her maiden name, well, the maiden name would be, I'm sorry, but her given name, which would be her first name. So if she's listed as Mrs. John Smith, you're not going to know what her first name is. At the end of the will, you're going to have those names of the witnesses, the mark of the testator, and it will also list who is to be the administrator and executor of the will. And the seal of a judge will sometimes be present on older wills. A lot of times this is actually just a little symbol drawn on there. Most last will and testaments that you will come across today, especially online, are copies. It is much more rare to find the originals because the originals were ones that were kept on the person or at least the administrator, and then they would turn everything into the court where it would be copied down. So these are some other examples of who might be mentioned in a will. Those most commonly are, of course, the spouse and children, immediate family. Sometimes you might have brother-in-laws, son-in-laws mentioned. Notice you're going to probably see more men's name than women. In the case that a person had no heirs, a neighbor may be mentioned, or the church they attended. Nieces and nephews also. If the man had young children, he would often name a guardian for his children under the age of 14. And then oftentimes the guardian would be a relative, but it doesn't always have to be. The reason for this is when the father passed away, the children were considered an orphan, even though their mother was most likely still living. Because remember, a wife does not automatically own property unless it is left to her. So that's why often a husband would assign guardians to his young children so that perhaps a new husband would not take advantage of what was theirs. So if the child was under 21 or 18, but older than 14, they were able to choose their guardian in most locations. And the reason I have 21 and 18 is because different locations had different regulations on when they were considered an adult. For much of the 1700s and 1800s, 21 was the legal age for a man to be able to own property and have his inheritance. This did not typically matter as much for females because most of them were married before the age of 18. And often the mother could be the guardian of the children, but it would have to be recorded that she took care of their financial status and would have to report it to the court. So guardians had to make a yearly account to the court of what was done for the minors they oversaw. These would be things that would include their school, where their clothes came from, where they were living, how much was spent on goods that could be sold and so forth. So basically an account of how money was spent. You'll also see the names of the administrators, the witnesses, and the judge. So why might someone not be mentioned in a will? There are several reasons children may not be mentioned. Often it has nothing to do with being disowned, as it is often thought of today. So some of the most common reasons why they may not be mentioned are that they are older children, so they may have already received their inheritance and begun their own family. So often the testator would mention some children already receiving their inheritance, but not always by name. This you'll see a lot more in the mid-1800s and early 1800s because you have so many individuals going west, going south to new land, all of these land grants. So when a son is in his 20s and 30s, he may set off with his own family. So therefore, he's probably already gotten what he may have been given in a will before he moved. A daughter may have received money or personal items at the time of her wedding as a dowry. A child may have passed away already, but their children may be listed in the will of their grandparent. And this you'll see quite often where it says, I leave to my daughter's heirs, or, someone who has already passed away, and occasionally they'll list the grandchildren by name. And on other occasional circumstances, a child may have been disowned or simply have upset the parent at the time, but that is very rarely the case. There are some wills that can be quite creative in what they do and do not leave. Some will make it explicit that their daughter is to receive this, but not her husband. Her daughter or their daughter and their grandchildren, but the husband is not allowed to have any of their wealth. So reading these original wills is always interesting to kind of see their personality come out a bit. Where are the wills found? Wills are kept at the county level in probate courts, usually by the year, but they can also be kept in files alphabetically, loose papers, as most places would call it. Many of them are online today, but not nearly as many that will exist. There are probably 5 times as many wills in existence than there are online. So just because you cannot find it on Ancestry, FamilySearch, and different sites like that does not mean it's not there. A lot of these are still at the original locations. Wills do not always show up at the time of the person's death, however, or at the time that it was written, because it could be years later before the will is probated and executed. So a will would be probated after the person's death, so that helps you narrow down the time of when they died. They would write the will, and then when it's probated, the person died in between those 2 times. This could be a couple of months, a year, 25 years. There are even some that 50 years difference. Reasons for this is that they could have been sick and got better, as I've already mentioned. It could be that they just had no reason to write a new will. And then again, it could have been that most of the people mentioned in the will had already passed away, and so therefore there wasn't a witness or a person in the will left to present it to the court. What other documents should you look for? After the person dies, like I just mentioned, the will be probated. So this means it's brought before the court and executed, put into effect, basically. This is when it's going to be recorded in the books, and then you're going to have a series of other documents to follow. So you find the date the will was probated in order to better determine the person's death. You might not be able to determine the exact date, but you know how to narrow it down. And look for any type of language that might be different in the appraisal or the estate sale that might have been mentioned in the will. So if it was a large time gap between when the will was written and when it was probated, you might be able to tell if the person acquired more property or wealth or if they lost it. When the will is brought to court, the other documents would need to be presented along with it or would ordered to be obtained. So an inventory of the estate would be taken by an impartial party to give a value to property and personal items. The appraisal will list all the items and their value. This does not happen for every will. This is going to be more for the case of someone who owns a lot of land and personal items. So if an individual, a farmer, he just had, say, 50 acres of land and he left that to his one son, that's not something that particularly needs to be appraised. It's just a single lot of land. Letters regarding a person's debt, if they had any, would be presented to the court by those collecting. And you can often find these in the appraisal because they will be taken out of it. So it might say, and they're usually called notes. So a note for $5. Occasionally you might see what it was for. It could have been, you know, flour, a shotgun, various items like that. Beneficiaries would come forth to make a claim of their inheritance. And the administrator or executor may have further paperwork to present after the will is probated. They would often be presented in the form of a petition. You can find these also, but it might be in different books, the court minutes, for example. I'm going to show a few examples at the end, and one will that I have, it's fairly brief, and it was written and the person died 2 years later. He only mentioned 2 children, where he left nearly everything to his wife and his one son, and then $200 to a daughter. And that was all that was mentioned. But he had several other children who were still living, and grandchildren. So 2 of his son-in-laws came and petitioned the court for inheritance for their wives. One for his children, but the other one for his wife who was still living. So that did not show up until 2 years later, and it's presented to the court. The court hears them out. There's a decision made whether for or against them. So those are types of records that you want to look at besides just a last will and testament, because that's not the end of the story. Always check court minutes before and after. They may be different mentionings of that person. If someone contested the will, a petition would be filed. And often there would be a published notice in the newspaper, if there was one, with information about the estate. In larger cities, if items were left to a son who had moved away, there would be an advertisement in the paper for at least 2 weeks telling that individual that if they wanted their inheritance, they had till a certain date to come and claim it. And this might seem silly, but that was the best way they had to communicate back then. There were obviously no phones or telegraph at the time. So often these individuals who had moved far away were either unable to get there in time or never even knew about the property or wealth that they might have had left. Once the will was probated and proved, it would be copied into the court records stating that it was proved. So that is the copy we typically see today, and it's usually one of those that it will have when the will was originally written, and then a portion below that will show when it was probated and have a different date. Now this is something to keep in mind when you're looking at much earlier wills in the 1700s and prior. Dates were different than they were today. So what we know today as a year, a month, a day was not adopted by the colonies until 1752. The Julian calendar is what is being used. So in 45 BC, a 12-month calendar was created by Julius Caesar based on the solar year. This is where leap year first came in, and it changed the beginning of the year from March the 1st to January the 1st. And then later, Christmas Day marked the new year. By the 9th century, the first day of the new year was March 25th. So at this time, March was the first month of the year. So this is why many of the months' names represent numbers, but not the order of they are today. For example, September is the 7th month, October 8, November 9, and so forth. But that was when March was considered the first month. And then you have the Gregorian calendar. In 1582, Pope Gregory XIII began a new style calendar, and most individuals adopted it. Now, the Pope would have been in Rome. Italy actually was not a country at that time, it was just Rome. So in other words, not everyone knew about this. 10 days were dropped from the month of October. January the 1st, once again, became the first day of the new year. And Protestant countries did not accept the new calendar, and they continued using the Julian calendar. So in other words, during this time, you have two different sets of dates going on between 1582 and 1752. So England, because they like to be difficult sometimes, they used both of them because you had different rulers who were going back and forth between being Catholic and Protestant. So their calendars changed a good bit. Therefore, double dating became common in England and in the early colonies. So some of these early records in 1600s, early 1700s, you might find two different dates written on the same document. In 1752, when England and the colonies adopted the Gregorian calendar, they had to make changes. So 11 days were dropped from the month of September, and the formula for leap year changed again. The beginning of the new year changed from March 25th back to January 1st, which all of that can be a bit confusing. So these are some things to keep in mind. Relationships. Just because a wife is mentioned, that does not mean that she is the mother of the children mentioned in the will. A wife's maiden name will rarely ever be mentioned. Brothers and sisters mentioned could mean in the gospel instead of by blood. In other words, it could be their brother from the church, so to speak, or it could be a brother in arms, which would be a soldier, someone they fought with. Sons were usually listed before daughters, not necessarily by age. So the daughters could have been the eldest, but the males are mentioned first. Always try to find the original will if possible, and by original I mean at least a copy of the original. When you find transcriptions of a will, a typed version, they can often contain errors. If you are transcribing an original will, transcribe everything exactly as it is written. Do not make spelling corrections or edits. Words and phrases did not always mean then what they mean today. So this is why it's very important to leave them exactly as they are written in the original. Also, always remember to cite the original will when you find it. That is something very important. Make sure you list the location, what book it came from, what page number, and if you found it online, make sure you have the link to the web page, and if it was on microfilm, the slide number, which is very important or very different than the page number. Make sure you read the will in the context of the time it was written. You cannot apply the information as it would be interpreted today. It's very different. And if possible, try to find the wills of the children, siblings, aunts, or uncles. Not necessarily all of them, but if a child passed before their parents, they may have mentioned their parents. I have found this where the eldest son died before both parents, and he made provisions for his son, mentioning his father. If a woman died with no heirs, often she would leave things to her nieces and nephews. So perhaps she was either a widow and had no children, or she had never married and therefore had a good bit of property that she was able to hold. These are some different websites to learn more about last will and testaments. You can pause the video to see these, and as long as you type in the name above it, you can get to these. So genealogy.com, Wills and Testaments. Family Tree Magazine has an interesting article on genealogy document detective. And then, of course, FamilySearch Wiki, U.S. probate records handout is very good. You can also look at probate records, could be the key to unlocking your family's hidden past. And then there's also the genealogy of wills and probates made understandable. So there's a copy of the will of Frederick Douglass, and it kind of breaks down what the various items mean, what the terminology at that time means. So I'm going to go over actually the handout for FamilySearch Wiki, because these are a lot of the terms that you might see in a last will and testament and in the books pertaining to them. So an abstract is a summary that contains only the pertinent details of a longer text. So you might often find books that are abstracts of court records. Their main purpose is to just pull out the names, the date, and what the document is pertaining to. Accounts are the reports of administrators, executors, guardians, trustees, and conservators of transactions for the estate. The administration of an estate is any proceeding relating to settlement of a descendant's estate, whether testate or intestate. And then an administrator is the person appointed by the court to manage the descendant's estate during the administration when the descendant left no will or they died intestate. Oftentimes you have several men in a town or county that you will see that they are administrators on dozens of wills, and that's typically because they were impartial parties that the court would just appoint for them to go and do a full appraisal and so forth. An adult, remember, is a person that had attained the age of 18 or 21 years. You always need to know the difference for the location. These did change at times, but a male typically could not own property or have his inheritance until he was 21. So that's why often you would see men being married later in life or past their 20s versus women marrying quite young. Affidavit is a legal written statement made under oath. An appraisal is an itemized valuation of real or personal property. The appraiser is the impartial person who estimates the value of personal or real property. To attest is to witness, offer testimony, or to certify that a copy is genuine. Beneficiary is one who will receive benefit from the estate. Bequeath is the act of assigning personal property in a will. Bequest is the personal property assigned in a will. A bond, the court required the administrator, sometimes the executor, guardian, or appraiser, to post a bond to ensure that he would complete his duties, or she. So a fee was to be paid if these duties were not performed. One or more persons were required to co-sign the bond with sureties. So you might find a bond for a will for $2,000 when in that time period you know that that is an astronomical amount, but it does not mean that they paid that much. It means that they are promising to do their job, and in the case that they do not fulfill it, they do have to pay that money to the court. A bondsman is the person who pledges a sum of money as bond in another's behalf. That's why you typically have multiple people signing them. A case file is all of the various papers that have been created throughout the probate process. These are bound together and archived by case numbers. A codicil, as I mentioned, is the addition of a will. To contest a will means to dispute it. Descendant is a deceased person, usually the person whose estate is subject to administration. And you will often see this written During the appraisal, it will say property of the deceased as abbreviation. Descendants are children, grandchildren, great-grandchildren, anyone who is of issue or an heir. Devise is to transfer real property through a will. Devisee is the person receiving real property through a will. A docket is a list or schedule of cases to be presented before the court. Dower rights are the rights that a non-owner spouse has in the real property. So that means that a woman who may have been given property as part of her dower, this is their property, not the husband's. Estate is all of the real and personal property left by a descendant in which he or she had a right or interest. An executor is the person or party designated in a will to act as the personal representative. A final account is going to be accounting of the total estimate and how it was distributed. And this is a document, if you're able to find it, it's usually can tell you even more about the person and who was close to them. Because if a lot of their property was sold, you can find out who bought it. It could be their heirs, it could be neighbors, relatives. It could be that even though property and personal items were left to a child, they wanted other things, so therefore they bought other things that were not divided. A guardian is a person appointed by the court to supervise over the financial affairs of one not legally competent to manage them, such as a minor, a disabled, or incompetent person. There were plenty of times that a will would be made leaving money and land to someone, and a different family member would go and claim that that individual is incompetent and not able to handle their own affairs, financial affairs. So they will declare that person, depending on the time period and the terminology, a lot of times idiotic, insane, incompetent, and therefore someone else is appointed to manage their financials, even if they are plenty old enough to handle things. An heir is the person who inherits property upon the death of the owner. Does not have to be a biological child at all. Intestate refers to the descendant who died without leaving a valid will. Partial intestacy occurs when the will does not dispose of all of the estate and they've only given a few things. Inventory is a list of all of their assets. So it is filed with the court by the personal representative in a court-supervised estate. Issue refers to offspring, biological children, legitimate, and even illegitimate children can often be mentioned in a last will and testament. Kindred are those that are related by blood, as distinguished from those related only by marriage. And we've gone over last will and testament. Legacy is a gift or a bequest of real or personal property by way of a will. The legate is the person to whom personal property is given by the will. Letters of administration refers to the formal document from the court granting authority to handle the affairs of the estate. Letters testamentary refers to the document approving the appointment of an executor and authorizing that person to administer the estate. Majority is when the person reaches their majority, they are of full legal age. Maternal, of course, is the mother's side. Minors are persons of the age, typically 18, are considered of legal age for most purposes. Again, 18, 21, they did vary. Minutes are the notes made of the probate court proceedings. Next of kin is the individual's nearest blood relative. Paternal is, of course, the father's family. Personal property are the assets other than land and those things permanently affixed to the land. Petition is the application to a court requesting the rights to settle estate. I can say this, posthumous child would be a child born after the death of his or her parent. After his or her father. And I have found a few cases of this where the individual, they could be sick or they know they are soon to die, but they will mention that their wife is with child at the time and it is their child. So even though that child is born after the father's death, they have still been acknowledged in the will. Probate is the process of administration of a descendant's estate under the supervision of the court. Probate estate papers are all of the papers that have been created throughout the probate process and are bound together and archived by case number. That does not always happen with smaller courthouses, but a lot of times in older courts you can find all of these documents listed and kept together in one location, which is wonderful. Probate fees refer to the compensation paid to the attorney in the probate case. A probate packet is the case files placed together. To prove the will means the evidentiary process validating that will. Publications were notices that were published so that creditors and others with an interest in the estate have an opportunity to collect debts or contact the legal representative. So that's why a lot of people wanted to check those papers, because if someone died and they were owing money, but the individual did not read or come to claim it, they were out of luck. Real property, land, or anything permanently attached to it. A register is a bound book in which official matters are recorded by the court clerk. A relic is a widow or widower. Oftentimes you will actually see this term on headstones. It might say wife, relic of William, so to speak, and that just means that she's the widow of William. Representative includes the executor, administrator, and guardian, also personal representative. Revoke is to cancel or make ineffective. You can find records in the courts where they revoke their last will and testament and then proceed to make a new one. Settlements are the final accounting of the estate and how it was distributed. Siblings, of course, that can be an individual's relatives or kinsmen, normally used to mean natural brothers and sisters, but not always. A spouse is a married person. Surety is a person who agrees to be liable for another's debts and obligations in case of default. Testament, the document in which the testator distributes personal property. This term is often dropped from the last will and testament. Testamentary items or matters mean that they pertain to a will. Testate, leaving a valid will at death. Testator is the person or male. A testatrix is the person making the will or testament who's a female. A transcript is an exact handwritten, typed or printed copy of a document or set of records. So the transcript is full and complete, where it differs from an abstract. Valuation is the process of arriving at the market value of the assets and the estate of a descendant through the use of appraisers and other objective proof. A will is a document that directs the disposition of the testator's property after death. And then witness of a will is one who certifies that he or she witnessed the making of the will by a testator, which is very important. So I'm going to show several examples of copies of last will and testaments now. So these are different examples. I'm actually going to go to a much older one to begin with. I want to make sure that it is pulled up. There we go. So this is the last will and testament of Nathaniel Everett. This is from 1749. And you can see that obviously this is a copy and it is not the clearest, but down at the bottom, you'll see where this would be the seal right here. You see the witnesses over to this side, and it says the mark of Nathaniel Everett, and right here it looks like he could just write his initials NE. So it does not always have to be an X, it just has to be a mark of that individual. And then this is the probate record. You can tell where it was folded, and this would have been the outside of it. So it has abbreviation Nathaniel Everett Will. And this is December 13th, 1749. So it will tell you when it was recorded, what county it is in. So right up here it has North Carolina, and it will give various names and information. The handwriting on all of these are going to vary greatly. This is the last will of his son, Nathaniel Everett II. And you'll notice that this one is obviously typed, and hopefully you can see it on your screen. It is quite long, actually, for wills at this time. So it starts, but it names several of the children. And then one reason this one is so important is it has a list of their children who are deceased. Sometimes they will have item 1, 2, and 3, and sometimes it just says item. So it says, I give unto the heirs of my son Joshua Everett, deceased, 1 shilling sterling. My daughter Lydia Griffin, deceased. My son Edmund Everett, deceased. My daughter Mary Ayers, deceased. And I believe it mentions another, but all of those children, that is information that by 1782, they are already deceased. And then he goes on to list all of his other children who are living. And it also lists his wife at the top. And it says, during her life, the plantation and land whereon I now dwell, my riding horse, bridle, and saddle, and a third part of all the movable estate. So you can tell that the transcript, they have not added punctuation, they have not corrected anything. This is completely written in the form or copied from the original. And this is the will of Nathaniel II's son, John Everett. And so again, this is a copy from the courthouse. So it will start over here. And again, several of them do start out the same way. In the name of God, Amen. And many will say, you know, know all men by these presents. Here, for example, it has Bulloch County within the first sentence instead of just off to the side. And instead of saying item, they have first, second, and third. They list several of their children in order. And then over here, you'll see where it says John Everett, but it does not show his mark. Even though all of these are written in the same handwriting, which is typically just probate judge at the time, it would usually say his mark if that's how they had to sign it. So by it not denoting that, it would indicate that he was literate. This is the last will and testament of William Holloway, who 1844. So again, you see this handwriting is all the same, but here it has his mark, and it's William Holloway Sr., and right over here, that's what the seal would be that I mentioned earlier. It was often just kind of drawn on there. So he, again, also has several different items where he leaves to his children, different things like that that you can find information. Let's see. So now I'm going to open up a different will. Which I'm sorry, I have to keep opening these. So this is actually a copy of the last will and testament of Aaron Cohn. This is one of those holographic copies. It is not in the best condition, as you can see, but you can tell the handwriting is quite different. It is damaged, of course. It is quite old. It is being held together between two panes of glass at the moment. But what is so interesting about this is it is 4 pages, front and back. And again, at the bottom, you can see the different handwritings. And that is always very important because you can tell whether that person actually signed their name, which I love seeing that original signature. But seeing even the witnesses and their various handwritings. So you know that this was written by them. And the actual copy of this is in the courthouse, so this is the original. Let's see. So this is the last will and testament of Joseph Anderson, which you've probably heard me mention before. This was written in September 25th, 1846. And this is the one that I mentioned. His son, he only left things to his wife, 1 son and 1 daughter. Almost everything was left to his beloved wife, Sarah, where it says up here, and nearly everything, tract of land, everything he owned, which he goes into detail about how much land, where it's located. He had land in Bulloch County and Thomas County. And he also specified for his son, Moses Anderson, to take care of his wife. Trying to remember where it said. But to make sure that she is comfortable during her life. So one thing this obviously tells us is that she was still alive at the time this was written, not necessarily when he died. There we go, to Moses Anderson to take good care of my beloved wife, his mother. So all of that is left, and then it goes on to leave most of the property after her death and everything to his son Moses. And it does say my daughter Nancy for provisions. And he left her, I believe, $200. But everything else went to Moses. At the time, Joseph still had a son up in Bulloch County, but he did own a great deal of land in Bulloch, so therefore that could be perceived as he had already received his inheritance. But he had several daughters who were living close by and grandchildren. And so this will was recorded in 46, and it was documented or turned into the court on 49, I believe. Sorry, handwriting is a bit different. So this is when Moses recorded it and turned it in. He was not a witness, but he was the one who had the copy of the will that he gave to the court. There we go. And once it was done, there was some dispute from his brother-in-laws Richard and Robert Roddenberry. Robert was married to Vicey Anderson, and Richard had been married to Fanny, both of Joseph Anderson's daughters. And the will listed nothing for his daughters or his grandchildren who were living close by. And so that's one thing that makes others speculate if Joseph had actually written this himself. Again, he could have very easily and just not left anything. What makes me wonder a bit is that at the top, it begins, "Know all men by these presents, that I, Joseph Anderson, do make my last will and testament." And it starts off right there. It does not say that he is of sound mind. It doesn't give any instructions as to burial, debts, anything. It just kind of hops right into it. And at this time, Joseph was in his 90s, so it would be fairly important for him to state that he was of sound mind at the time, which this document does not. So be careful when you read into these and see exactly what they say. Read the entire document, beginning to end, before trying to break it down. If you try to copy out names too soon, you're going to miss little bits and pieces, so you want to read the entire document together first. And this is, well, I'll show the other one. This is an abstract of Jeremiah Glenn's will. So this is kind of how you would see the difference between an abstract and a transcript. So it says that the will is dated the 28th of January, 1814, proved August in court in 1814. So about 7 months later was when it was proved. It has Jeremiah Glenn with an X, meaning that he signed it right there. But notice here it has wife Patsy Glenn, and someone has written over it Betsy. His wife was actually Elizabeth, but she went by Betsy. So that's why abstracts and transcriptions can be a bit different. And in this abstract, it has pulled the names of his sons, James Thomas Anderson Glenn, George Washington Glenn, and then it says to my daughter Nancy Woods heirs. And that means that most likely his daughters are deceased. It has Pamela Glenn, Polly Eldridge, and then you see here a question mark. It has Kitty Horton Glenn and Lucy Glenn. There was some confusion whether this was a middle name or another person. And then it lists the executors. It does say brother, William Glenn and James Leda, which this is one of those we have still been trying to figure out if he was a Glenn or possibly a half-brother. So this is an abstract where it just pulls that basic information. And then over here is the original. So you can see it is written very different handwriting, all by the probate judge at the time. It goes in and does say all of the different names. There's his daughter, and it leaves different things to each of his children and some of his grandchildren. And then right below it, this is where the will was probated. So you can see it has, I believe that's August 4th, 1814. So this is that portion at the bottom you always want to look for when you find last will and testaments in online or in the court books, because just because it was written at this time doesn't mean the person died. But in this case, this gives us a very close window to when they died, within probably a 6-month period. This is an example of an appraisement for John Michael. So over here you can see the appraisement of the estate of John Michael, deceased, and appraisers are Stephen Denmark, Joseph Rawls, and I can't quite read the last one, but it will give the cost of all of the individual items. You might see do or ditto often so that they don't have to write so many times. And this will tell you kind of what they had. So you see they have a watch, bedroom furniture, which remember I said beds and things were much more expensive then than they are now. Plantation tools, plows, carts, a gun, various guns, beehives. That's something a lot of people wouldn't think of today, but they had beehives, griststone, baskets, forks, hooks, copperware, a bag. So all of these little items that today we might not take a second thought about were very important back then and would be in those appraisements. Trying to see if there are any others that I've not shown. This is one that was kind of interesting to me. So this is the copy that I guess you would consider the original in the court book. It's on page 15, and it's Bulloch County for Henry Parish. So, and this is a will from 1800. And you can see over here at the bottom, or on the other side of the page, that's the summary of someone's appraisal. So this is a fairly short will. It tells you it's June 28, 1800, Henry Parish, and you have to look hard, but you can see the little X between his name that's right there. But when I first came across this was the copy I found. And if you notice, this looks quite different. It almost looks like it's on notebook paper, where most of these are not online paper. And it has X1 and X2. So, and it's also labeled at the top, which is a bit unusual. Even though this is a will from 1800, this is in the front of a book that is supposed to start in 1816. So for some reason, this will was copied in the front of a book much later. So this is a second copy of it in the courthouse. And again, you can see that they have written his mark there. And it looks almost like two different handwritings here as well. And then at the bottom, you see not the cleanest handwriting, but someone else had written this. So always try to find that. And this does tell you what page it was on for the original and who wrote that information. So that can be quite interesting once you find multiple copies. See if they are exactly the same. And one other that I thought I had here. It might be in a different folder. Let's see. So this is an appraisement of Nathan Bruton's last will and testament. He's one of these that he wrote his will, and he did not die until I believe 20 years later. So he wrote it, I believe, 1825 and died about 1855. So you're going to have various appraisements over here of his land, which he had a ton of land. He had over 8,000 acres of land, I believe. And then you'll see all the different names of the appraisers over here. And then this is the inventory of all of his estate. So again, it goes down and you can see all of the various things that he owned and how much it was worth. And then over here, these are credits of Nathan Bruton. So remember how I mentioned notes? So this is money that he owed individuals, and some of them notes it could be someone else who owed him money. This is a copy of his original last will and testament that is in the court books instead of just the photocopy. Transcription of his will. And then also remember how I said there are some that would declare their siblings incompetent. So here you have inventory of the rights and credits of Nathan Bruton, deceased. And then it says petition filed by Benjamin Bruton stating that Jemima Hendricks is either an idiot or a lunatic. This was their sister. And so shortly after he died, because the inventory was completed December 10th, and so less than 3 months, they basically said that their sister was incompetent to obtain her inheritance or manage her money and land, and so therefore they became her guardians so that they were able to manage everything. So again, if you have any questions, just let me know. You can email me, post in the comments. Last will and testaments are basically a window into your ancestors' lives. It can tell you how that person felt about others, what things they owned, what they did, who they considered family, even the type of language they might have written in, because sometimes it does reflect very personal phrases they might have used. So go try to see if you can find last will and testaments of your ancestors and see if you have surprises that come in store. I hope you find some interesting things.